Okay, so to be efficient, there's going to be content creators that are going to cover the whole thing. I'm just going to cover the three claims that are surviving. Okay. Go ahead and, like, I really recommend for you to go and read the entire document. I have not finished reading all of it, but what I've read so far is actually really good. It gives excellent explanations as to why, like the reasoning behind it, and it really is worth reading. As a matter of fact, if you read Blake's amended complaint, like, sorry for you, but if you ever read that, heck, that was horrible. That was a nothing burger. If you took the effort to read that, take the effort to read the 152 pages. It's so good. Well worth the read, really. So, Retaliation. Lively brings retaliation claims against It Ends With Us movie and Wayfarer under Title VII, FIHA, and California Labor Code section blah, blah. She also brings aiding and abetting retaliation claims under FIHA against Nathan, Tag, and Abel. Clarifying that Count 7 of the SAC involves only aiding and abetting retaliation, not harassment. The court has granted judgment on the Title 7 and Sections 1102.5 claims on the grounds that Lively was an independent contractor. Let's read the footnote here. It says, there may exist a question regarding the application of the FIHA retaliation statute where the allegedly retaliatory conduct has a sufficient territorial nexus to California, but the underlying harassment about which the plaintiff has complained does not. No party has raised that issue on this motion, so the court has no occasion to address it. Okay, however, a person does not need to be an employee to bring a retaliation claim under FIHA. He cites Fitzsimmons versus California Emergency Physicians Medical Group, and it talks about, like, prohibiting retaliation against any person who engages in protected activity. Indeed, as previously explained, the Wayfarer parties have not moved for judgment on Lively's FIHA claims on the basis of her employment status. The court thus turns to Lively retaliation claims under FIHA. In doing so, the court finds that there exist genuine issues of material fact requiring trial as to the claims against It Ends With Us movie and Wayfarer. Nathan and Abel, however, are entitled to summary judgment with respect to the aiding and abetting claims pleaded against them. The court withholds judgment with respect to Tag's liability for aiding and abetting retaliation. Before proceeding further, the court notes that the discussion below treats It Ends With Us movie and Wayfarer both as Lively's employer, not to suggest that there was an employer-employee relationship, because there was not, but to conform to the language of the statute and case law, which we use the term employer even in cases involving independent contractors. Lively has argued that It Ends With Us movie and Wayfarer were her joint employers under FIHA. The Wayfarer parties have responded that they never made any argument to the contrary, but that if they had, that there would be a reason to reject Lively's position. The court will not at this stage grant judgment in Wayfarer's favor based on a mythical argument that is expressly says it never made it in its opening briefing. The court will therefore treat Wayfarer and It Ends With Us movie as joint employers under FIHA for present purposes. Legal background. FIHA provides in broad terms that it is unlawful and an unlawful employment practice for any employer or person to discharge, expel, or otherwise discriminate against any person because the person has opposed any practices forbidden under this part, or because the person has filed a complaint, testified, or assisted in any proceeding under this part. Although this subsection mentions discrimination, it has long been understood to prohibit retaliation. The statute defines person as including one or more individuals, partnerships, associations, corporations, limited liability companies, legal representatives, trustees, blah, blah, blah. Okay, let's skip. FIHA's anti-retaliation provision is intended to aid enforcement of the FIHA and promote communication and informal dispute resolution in the workplace. As with the retaliation claims brought under Title VII, FIHA retaliation claims contain three elements. A plaintiff must establish that she engaged in protected activity. The defendant subjected her to an adverse employment action. Here is the crux of it all. Now Blake Lively has to prove that there was an adverse employment action. Dude, she took away the film buy credit for the director. She got him to sign a PGA letter, like a reference letter for her, all kind of stuff. Like the director didn't get to edit or see the edit. Like, he saw the movie at the movie theater, and he was a director. Are you kidding me? Adverse employment action would have been her getting fired, reprimanded, whatever. None of it happened. On the contrary, you know who got reprimanded? Baldoni. He got yelled at, or somebody got onto him for 5 hours. And the guy wasn't even an employer or employee or nothing. It was freaking the husband. And number 3, causal link exists between the protected activity and the defendant's action. Man, this is gonna be an uphill battle. Yes. Freak to the yes. Freak to the yes. Oh my gosh. I love this for her. The first part of the plaintiff's prima facie test establishing protected activity requires demonstrating that the plaintiff took steps to oppose practices forbidden by FIHA. Okay. Of course, a plaintiff's conduct may constitute protected activity not only when the plaintiff opposes conduct that ultimately is determined to be unlawfully discriminatory under the FIHA, but also when the plaintiff opposes the conduct that she reasonably and in good faith believes is to be discriminatory, whether or not the challenged conduct is ultimately found to violate FIHA. So basically, to put another way, a plaintiff may bring a retaliation claim where she has opposed conduct she reasonably believed to be discriminatory under FIHA, even when a court later determines that the conduct was not actually prohibited by the FIHA. Okay, so it's just saying basically she can bring those claims, and the court may find that that's not prohibited, but she can bring those claims to court, basically. In a case where a court has not found any underlying FIHA violation, the question is the reasonableness of the plaintiff's belief that she was opposing a practice prohibited by the FIHA. This reasonableness inquiry contains both a subjective and objective component. A plaintiff must not only show that subjectively and in good faith believe that her employer was engaged in unlawful employment practices, but also that her belief was objectively reasonable in the light of the facts and record presented. The objective reasonableness of an employee's belief that the employer has engaged in a prohibited employment practice must be measured against existing substantiative law. A plaintiff's articulated belief that the defendant is engaging in discrimination will not suffice to establish protected conduct for the purposes of establishing a prima facie case of retaliation. Oh my gosh! Okay, so let's read this again. A plaintiff's unarticulated belief that the defendant is engaging in discrimination will not suffice. Okay. All right. So she has to speak up. Got it. And I mean, she told Aunt Janetti, I guess. Where there is no evidence that the defendant knew that the opposition was based upon a reasonable belief that the defendant was engaging in discrimination. A plaintiff need not expressly inform the defendant that she believes the defendant's conduct was discriminatory and in violation of FIHA. However, complaints about personal grievances are vague and or conclusory remarks that fail to put an employer on notice as to what conduct it should investigate will not suffice to establish protected conduct. The relevant question is not whether a formal accusation of discrimination is made, but whether the communication to the defendant sufficiently conveyed the reasonable concerns that the defendant has acted or is acting in an unlawful discriminatory manner. Oh my, this is going to be an uphill battle for her. Anyway, follow for part 2.